Hey, this is Brian Terrian here, and I'm shooting this video for you because I just got done reading a message from a member by the name of Shari, who went to her Social Security disability hearing and reported back to me that she was absolutely distraught that the attorney that she had hired didn't collect all of the medical records for the judge to review, and it made it really difficult for the judge to assess whether Shari is disabled and qualifies for a disability check or not. So in this short video, I'm going to give you some tips as to what you can do to understand the process and take responsibility for either managing it yourself if you're one of those rare individuals that's going to court on your own, or to make sure that you hold your attorney, lawyer, non-attorney representative accountable for it. So this is the who, what, when, where, how, and why, actually. So my disclaimer, I'm not an attorney. I've seen over 10,000 cases get approved. I have a pretty good idea based on that what works and what doesn't work. But I will share this, that the rules of the game are you are treated for conditions, and those conditions cause limitations on your body that you're not able to work. That's a very simplistic explanation. And that treatment is done by a doctor, and Social Security can review the records and validate that you qualify for disability. So there's no records to review. It makes it really hard. So the first thing is why you want to do this, and why you want to get all of your medical records in, and why I preach to people about ongoing treatment and building their medical evidence. And so when you get into court, and the judge reviews the medical records, you can say, oh, I see that you're treated every month and you have these conditions and you're taking this medication and it's unfortunate and you're not able to work and you're approved for disability. So that's the simplistics as to why. So who you want to have the medical records from is any doctor treating source that you're seeing, as a general rule. And so what is beneficial throughout the process is to keep a list of doctors. I, in a recent video, showed individuals how to organize their case file by using a free online secure resource called Google Drive. I'd recommend doing that, and just track your doctors, names, addresses, first date, last date of treatment. That's the simplistic thing to do. Then you're all locked and loaded. So when your hearing date comes, that you have a list of the medical records that you want to provide. So that's the who. 3 is what. Well, like, what do you want to have in those medical records? Well, really everything. There's no such thing as too much evidence from what I've learned. So you want to have from the date of when you were became disabled at the very minimum. So if it was June of 2017 that you were not able to work, you want to have at least from then. Ideally, you want to have medical records from months prior that show any supporting evidence that you were diagnosed with something, you were treated with something, and it became gradually, increasingly more challenging for you to work up until June. That's the full meal deal. Now, of course, I don't want to disrupt any of your attorney's work. You can get their advice on this, but that's generally what I hear from individuals that win these cases day in and day out. So when do you want to start doing this? You are given a opportunity to submit evidence earlier prior to having a hearing date established, and there's a form that's SSA 4631, and I don't see many that practice in this area that actually do that. They get all the medical records and submit them then, and the general feedback is that nobody's really going to review it till it gets to court. So the best practices that I see out there are that when you have your notice of hearing, like you have an actual piece of paper that has your hearing date on it, that is when you want to swing into action. You usually have plenty of time to do this, and make sure that if you're using a representative, you submit to them the medical records or the list of the doctors and the dates, and say, you know, this is the evidence that I want to have submitted, and they should be actually proactively coming after you. But in the Shari situation, this attorney spaced it and he missed the whole show. So That's why I'm doing this video. When you get your notice of hearing, and you'll have a date, you'll have a time, you'll have months in advance, usually a month and a half at least, to get your medical records. And it's typical that the attorney will request these, and they'll compile all of these and they'll submit them to the judge. Now, what happens if you don't get all the medical records, or your attorney, lawyer, or representative doesn't get all of the medical records? This does happen. Some doctors and some organizations, I just have disastrous medical record retrieval results. So you will eventually get them. You can go in and actually extract them yourself or put pressure on them to deliver them. That's one easy way to do it. But if you don't have them at the time of the hearing, you can submit them afterwards. Now, the Social Security has a 5-day rule that you need to have all of your evidence to be considered at the hearing in 5 days before the hearing. So keep that in mind, that you want to have them submitted, so you're working with that. And you know, there may be some exceptions outside of that if you can bring something into the courtroom, you know, but I wouldn't count on that. So use the 5-day rule. So if it doesn't get in and you have outstanding medical records, which does happen, then you can have, or your attorney, lawyer, representative writes a letter to the judge and says, listen, hey man, we have tried to get these medical records for this period of time. We're going to continue to follow up on these. We expect that we will get them, but we do not have them in time for the hearing. So if you have 10 treating sources and you get 8 and you have to put 2 on the letter, all right, you've handled the process properly. The judge understands, and everything is good when you go into court. So if you follow these tips, you're going to have your medical evidence locked in. Be well prepared. If you don't have a hearing date, file this video away somewhere so you know what to do in the action steps when your hearing date comes up, and you can get your disability benefits approved. This has been Brian Tarian. I hope you enjoy the work that we do. Stay tuned for more from the Disability Digest. Make it a great day.